Lawyer challenges Fed's claim that vaccine travel mandate lawsuits are moot in court hearing. A lawyer representing two applicants challenging the federal travel vaccine mandate told an Ottawa courtroom on September 21 that the issue isn't moot, as the Attorney General has previously argued in court, since the federal government could bring back the measure at any time. Mandates are not a relic of the pandemic past, said lawyer Sam Pressfellows, who represents businessmen Carl Harrison and Sean Ricard. Pressfellows argued the Attorney General has not submitted any evidence that mandates won't be reimposed. After the Liberal government lifted the vaccine mandates on June 20, the Attorney General filed a motion to have 4 lawsuits against the mandate be declared moot and struck. Justice Jocelyn Gagne is hearing the arguments from the Attorney General and the applicants in Ottawa. Justice Canada Senior General Counsel J. Sanderson Graham said the federal court should not hear the case because the interim orders that implemented the mandate are no longer in force and do not exist as law. Graham said the applicants' rights are not being affected since the mandates have been repealed, and they have already received the only proper remedy available, having been re-granted the ability to travel. Graham also warned the court against making an unnecessary constitutional pronouncement that he said could have a deleterious effect on future cases. Implications. When the government announced the vaccine mandates would be lifted on June 14, its statement emphasized the measure was being suspended and could be brought back if deemed necessary. Graham argued that such statements for the media have no legal value. Pressfellows pushed back on this assertion, saying the concept was communicated by cabinet ministers and should not be dismissed. These words cannot be trivialized because they don't come from a lawyer, Pressfellows said. Pressfellows also mentioned a now partly declassified briefing that was provided to cabinet in June before it took the decision to lift the mandates, which states that mandates would be only temporarily suspended and brought back in the fall with an up-to-date vaccination requirement if health conditions warrant. Pressfellows said the court needs to address the constitutional implications of the case, because the mandatory vaccination scheme meant Canadians who chose to assert the charter right of bodily autonomy had to forego their mobility rights, whereas those who complied with the mandate traded bodily autonomy for mobility. This conflict shouldn't be allowed in a constitutional democracy, Pressfellows said. Other applicants challenging the travel mandate include People's Party leader Maxime Bernier, former Newfoundland Premier Brian Peckford, and Quebec lawyer Nabil Belkacem. The legal proceedings have shed light on the inner workings of the vaccine mandates, with government officials behind the policy testifying, along with public health officials. Testimony thus far has suggested the government had limited data on in-flight transmission of the virus and assessed the risk of transmission as low, and had very little data on the impact of vaccination in transportation. Despite ministers saying all decisions behind the mandates were guided by science and public health advice, the official who wrote the travel mandate policy said she couldn't recall ever receiving a direct recommendation for a vaccine mandate from Health Canada.
Thank you very much for having me.
You filed a lawsuit with the Federal Court of Canada asking for a judicial review of air travel. On what grounds do you hope to win?
Well, I think that should be obvious to everybody now. There is a section of the Charter of Rights and Freedoms called Section 6, which says that every Canadian has the right to travel anywhere in Canada or leave Canada. And obviously that has been violated by restricting the rights of certain Canadians from not being able to get aboard a plane to go to a nearby province or to leave the country. It also violates, of course, Section 7, which is my rights to life, liberty, and security of the person. It violates my rights under Section 15, which is a right of equality before the law, which I just don't now enjoy. So there are a lot of rights and freedoms being violated by this particular travel ban by the federal government, as the rights are also being violated by a lot of provincial measures that are now in place.
But Section 33 of the Charter also allows exceptions to override the law. Why would that not be applicable
Not Section 33. Section 33, you're talking about notwithstanding clause. So it means government's got to go to court, got to go to the legislature and pass special legislation in order to allow to do this.
All right. And
they're not using Section 33 because they're afraid to go to their legislatures because they know what they're doing is not constitutional and they wouldn't get it passed.
You don't think the federal government would get this passed?
Well, they haven't even tried, have they? So they're trying to do it under Section 1, which abrogates the rights and freedoms of Canadians. But I was there. I helped write the Charter of Rights and Freedoms. I'm the only First Minister alive who did.
Yep.
And that was meant for when the state was in peril, when it was an insurrection or a war. That's why we put the Charter of Rights in the Constitution, not in a federal act or a provincial act, because constitutions are permanent values, not temporary values that can be changed with every new parliament. And so that therefore what the government of Canada is doing, and all the governments are doing, is violating the sacred rights and freedoms of individual Canadians enshrined in the Charter of Rights and Freedoms.
Okay, point taken.
Then there are some who will say, for argument's sake, that Section 1 does apply. My answer is yes, I will engage in that argument, because there are 4 tests that have to be met, even if you're in a war or insurrection, for Section 1 to apply, whereby they could override our rights. And the governments of all the provinces and territories have not met those 4 tests, even if Section 1 applied. So that's why I'm in court, because I know and I'm confident that what the federal government is doing in the travel ban violates my rights, for which they have not provided any justification.
But we have infringements on our rights every day. I'm required, as are you, to put a seatbelt on, to obey the stop line. I'm not allowed to smoke in a restaurant. Why is this any different if it's
you're not serious. I mean, there are fundamental rights of freedom of expression. We're talking about freedom of expression. We're talking about freedom of conscience. We're talking about freedom of religion. We're talking about freedoms of assembly, freedom of association. We're talking about life, liberty, and security of the person.
Because of the travel?
Travel across the country. We're not talking about those kinds of things that you're talking about. One is apples, the other is bananas.
Well, let me ask again, though, but we do accept infringements on our freedoms.
But you hear what I just said. One is apples and the other is bananas, and you won't accept my argument.
But, Mr. Peckford, let's talk about getting on a plane. We do accept infringements on our absolute liberty whenever we get on a plane, don't we? We can't carry weapons on board.
Of course, but those are not the fundamental freedoms. There's a difference between basic fundamental freedoms and rights and what you're talking about. And this is very, very dangerous, what you're talking about, because you're trying to equate those kinds of normal everyday activities with the basic rights and freedoms of Canadians. And that's very dangerous to go down that road. That's why we were very careful in the Charter of Rights and Freedoms of wording the things the way we worded them, and to associate these highly secondary provincial and federal issues with the national document, the Constitution, demonstrates a lack of understanding of the difference between the Constitution and ordinary federal and provincial law.
Okay, but again, we're focusing on travel here, and you could travel back to Eastern Canada as it stands now. You just couldn't fly under the current restrictions.
I can't fly, and I can't go on a train, so I've got to drive. Sure, if you want to go back in time, and we'll take away the plane, and we'll take away the train, and we don't have a Canada anymore. I thought progression meant that, once you you accept these things as being normal practices, that to then take them away would be interfering with your freedoms. To think that I can drive 5,000 miles in the middle of the winter to see my daughter in Newfoundland, it seems to me to be an unreasonable request when there are other alternatives available which have been unilaterally taken away from me.
But I know you see it as apples and bananas or apples and oranges, but the point of my question was we do accept... I
never said we didn't, but I'm telling you, in my view...
So I don't understand why this one's different. That's what I'm trying to... I'm asking in good faith. Why is this one different?
It's a difference in kind, not even a difference in degree. One is fundamental freedoms and rights, and obviously you really don't understand. The Charter of Rights and Freedoms says I have the right to travel, right? It didn't say by car only. I have the right to travel anywhere in Canada or leave Canada. That's a fundamental right as a citizen that was bestowed on me by the Constitution of Canada. Not by a federal law, provincial law, not by some other secondary things which we accept as being normal behavior in an organized society. That's one thing. This is a far more fundamental thing, and the quicker Canadians recognize that, that's why people are out on the streets. That's why there's a truckers' convoy.
So why not focus on those trucker restrictions, cross-border restrictions, rather than air travel?
Because in this particular case, with air travel or travel ban, I'm talking about all Canadians from coast to coast. Every Canadian is affected by this travel ban, so people can understand it quite easily. That's one of the reasons why. And it's so blatant as well, because they use the Aeronautics Act, which is used to make sure a plane is safe. Nothing to do with a person's right to travel. So it's ultra vires. The act that they use is one that they can't use to bring in the travel ban. It doesn't apply.
So what would it take to resolve this dispute?
What would resolve this is to restore the Charter of Rights and Freedoms to its rightful place in the democracy of Canada. That's why I've taken the lawsuit, and others have taken the lawsuit. The courts have to rule that what the government is doing is unconstitutional, and they were unjustified in doing it because there were alternative means to combat and mitigate the virus.
Okay, so what are those alternative means?
They were emergency measures organizations, which were completely ignored, all during the pandemic, right up to now, that are spending millions and millions of dollars, 10 of them, right across the country in every province, that are planning just for these kinds of circumstances. And what the governments did was took a single-issue approach rather than a multifaceted approach to attack this virus.
Would you
Emergency measures organization, early treatment, and adopt the Great Barrington Declaration. And those measures would not have infringed upon bartered our rights and freedoms away.
Would a mask mandate on planes or in other public spaces? No, I'm asking you, would a mask mandate...
No, I'm asking you back. This is my answer back. Have you read anything? Almost every single study, 400 of them, have showed that masks don't work. Aerosols, part of the virus, go through the masks.
But that's not what the majority of epidemiologists and scientists 100%. And peer-reviewed studies are telling us. So if you were premier and your public health officer and all these experts in the British Medical Journal and the New England Journal of Medicine were telling you that masks and vaccines were effective, what would you do if you were premier right now?
No. The premise of your question is quite wrong. Quite like the Lancet and the British Medical Journal and others have had to backtrack on a lot of those studies. So there was a lot of new information came out in that first year, which completely contradicted what you're saying right now. And so if I was premier of the province, I would have done what Ron DeSantis did. I would have got out and gotten more information, more scientific information, which combated and contradicted a lot of what my own people were telling me, and looked at the bigger picture, and looked at the Great Barrington Declaration, and brought in measures which never infringed upon the rights and freedoms, but yet protected those who were vulnerable on this virus.
Even as your hospitals were filling up and you had doctors and nurses bleeding.
That's a myth. The hospitals weren't filling up. And if they had have implemented the early treatment, there would have been absolutely no problem with hospitalizations of any kind, because 25 to 50% wouldn't have gone to hospital in the first place.
If that's all true, why do you think 10 provincial governments and the federal government have all acted as such?
Because they've been duped, and CBC has been duped. That's why a lot of us, like me, up until you call now, have been shut out from all the main media. I've written the media all across Canada, and they won't carry me. And this is the first call I've had from CBC, even though I've been out there for a year and a half speaking loudly about this.
That's Brian Peckford, a resident of the island for a few decades now, but the former Premier of Newfoundland and Labrador, who has filed an application in federal court this week. That's why we're talking to him. He and a number of others are challenging the government's COVID restrictions on air travel.